5 defendants, 1 courtroom, and a web of lies, violations, and shocking twists. From probation violations to failed plea deals, this courtroom drama just hit a boiling point. Judge Raquel West isn't holding back, and the stakes couldn't be higher. What will happen next? Keep watching as this story unfolds and find out who's about to get served. Asterisk, do you think any of these defendants deserve a second chance, or should they pay for their crimes? Drop your thoughts in the comments.
On Mr. Boyd?
On board, yes, ma'am.
Okay. Is it
It's
a?
a rejection.
Okay. Good morning, sir. Are you David Alexander Boyd?
Yes, ma'am.
And Mr. Boyd, in cause number 25, DCCR 0720, you're charged with a third-degree felony offense of deadly conduct, discharging a firearm from March 20th of 2025. And what that means, sir, is that if you go to trial and you're found guilty, the range of punishment is between 2 years and up to 10 years in prison. Do you understand?
Yes, ma'am.
And I'm going to get a plea bargain rejection. What is the offer?
The state's offering 10 years, probated for 10 years with a $2,500 fine, standard conditions and no contact with a couple of complainants, as well as stay away from the Little Woodrow's establishment.
Sir,
Yes.
spit whatever is in your mouth out in that trash can over there. So you've signed a plea bargain rejection with your attorney, Mr. Jeffries, and it's going to show 10 over 10, right?
That's right, Judge.
So it's for, if you wanted to enter a plea of guilty for a 10-year term in prison, that would be probated. You'd be on probation for 10 years. You would be ordered to pay a $2,500 fine to follow all of the rules and conditions of probation. You have every right to reject that and have your case set for trial. I want to make sure you understand today what your options are if you wanted to plead guilty and what your possible consequences are if you go to trial and are found guilty. Do you understand all of that?
Yes, ma'am.
And do you want to reject that offer and have your case set for trial?
Yes, ma'am.
All right, we'll get it set for trial. Mr. Coleman, is there any reason to believe that that offer would change?
Not at all, Judge.
So, Mr. Boyd, I want to make sure you understand that after today, I don't accept plea agreements once they're rejected. So unless new information comes to light with your attorney or the district attorney's office, then if you change your mind later and want to enter a plea of guilty, it would be to something different than this or open to the court. Do you understand?
Yes, ma'am.
All right, then we'll get your case set for trial and Mr. Jeffries will begin preparation. And if y'all will just send that through, I'll
Just see.
sign off on it. Okay, perfect. You're free to go, sir.
Thank you, ma'am.
Good morning, sir. You're Michael Thomas.
Yes, ma'am.
And this is 23 DCCR 0530. Mr. Thomas is charged with indecency with a child by sexual contact. We had reset the case because there was a family proceeding that you guys were going to get the transcript and review. So what is the status at this point?
We've had a chance to receive everything from family court and review with judge, so at this time we're ready to move it back to the trial docket.
Okay, so nothing's changed as far as, let's see, what the, I rejected a plea back in July. Was there
Right.
any other negotiations after that with regard to any different pleas?
No, the family court hearing was shortly after that rejection occurred. So once I found out about that, that's when we started trying to get that information.
Okay. So it was a 4-year cap, so, okay, all right, and Mr. Nichols, as far as Mr.
I
Hoffhower's.
don't see any notes indicating any other issues, Your Honor.
All right, we'll set your case for trial, make sure you stay, and so are you appointed?
I'm retained.
Okay, all right, so we will set your case for trial. Mr. Lewis will begin preparation. Make sure you stay in touch with him so you can visit and be ready at that trial date. All right, thank you. So you tested negative this morning. Obviously, that's very good. It is extremely important that you have that drug patch on correctly at all times. So if it falls off or something's not testable, then the only thing I can assume is that it's probably positive, and you don't want me to assume that. So make sure whatever it takes, you keep it on, you change it when you're supposed to, and we won't have any issues with that, okay? So now, let me go back and punch your case real quick. So this is your initial appearance in cause number 21-36752. So you're on probation already for unauthorized use of a vehicle, a state jail felony. And it looks like you were arrested again in August. And I set you a bond. And since you've made that bond, have you tried to hire a lawyer? Speak up, please. Right, so when you're in custody, I automatically give you a court-appointed lawyer. But once you make a bond, I expect you to try to hire your own lawyer. So what I'm going to do is reset your case for about 30 days to give you some time to try to hire someone. If you get someone hired before the next court date, just bring the reset notice that you get today to that lawyer and they'll tell you what to do. If you're unable to hire someone before the next court date, then I'm ordering you to visit with at least 3 lawyers. They all charge different amounts, they have different payment plans. Bring me back the names of the lawyers that you've talked to so I know you're trying, and then we'll discuss your options. If you don't do that, then when you come back, your bond will be raised and you'll go back to jail. Do you understand? You're still on probation. It's very important that you're reporting also and doing everything else you're supposed to while you're on probation, okay? All right, step in front of the clerk. She'll give you your reset notice. Good morning. Are you Dale Johnson? And this was the final reset on Ms. Johnson's 3 cases. And so what is the announcement?
Regrettably, Judge, the defense announcement this morning is not ready. Despite our diligent efforts and the efforts of our expert who is based out of town, our expert has experienced some health issues that have prevented him from completing his analysis and the report that we need to responsibly rely upon. And we are requesting 1 short reset to allow our expert to complete his work and his report.
Well, we talked about this last time, and so here's what we're going to do. If you were hired back in August of 2024, so what you need to do today is a rejection of any plea offer. If anything changes between now and the trial date based on that report, as soon as you get the report, you let the court and Mr. Hoffpower know. If there's some change, then I would consider accepting whatever the offer has been. Typically, I don't after there is a rejection, but because of the circumstances, it's time to get this case moved one way or the other. So I'm going to go ahead and get that rejection done today.
Okay, Judge.
It's on the tablet, and then it'll go on the trial docket. And again, as soon as you get that, if something changes, let me know. Otherwise, be ready for trial at the next trial date. You can let Mr. Hoffpower know that as well.
Thank you, Judge.
I'll hold it while y'all do that paperwork, and then I'll recall it.
Thanks, Judge.
Yes, sir. Good morning. You're Ray No.
Good morning, ma'am. Yes, ma'am.
And will your client waive the formal reading of the indictment in each case?
He does.
Just a second. Figure out what today is. Mr. No, in cause number 25, DCCR 0386, you're charged with the 2nd-degree felony offense of intoxication manslaughter with a vehicle from December 11th of 2024. And how do you plead to that charge?
Guilty.
And y'all have marked here aggravated. What is,
Defense counsel put that here.
Yeah, they charged it as aggravated with a vehicle, I believe. It was aggravating.
It's just a garden variety intox.
yeah, I'm gonna mark that out because I think that might
Feel free,
have
Judge.
some
Different context.
context at sentencing that you may not want. All right, so it's, so how do you plead to that charge?
Guilty.
And are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you actually did what they've charged you with?
Yes, ma'am.
And then in cause number 25, DCCR 0387, you're charged with the state jail felony offense of driving while intoxicated with a child passenger from December 11th of 2024. And how do you plead to that charge?
Guilty.
Again, are you pleading guilty freely and voluntarily?
Yes, Your Honor.
And are you pleading guilty because you did what they've charged you with?
Yes, Your Honor.
In each of those cases, I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Franklin?
Yes, Your Honor.
Do you fully understand them?
Yes, Your Honor.
And do you understand that it's well, first of all, it's the way this is written up is that you are pleading open to the court. There's no agreement. Is that correct?
Yes, Your Honor.
And so you guys, a couple things. I need the other one sent back. So is it on the trial court certification of defendant's right to appeal? On this case, the state jail, the admonishments were signed saying that they're waiving the right to appeal. And then on the certification, it's actually 2 of them were checked off. One is the defendant has waived the right of appeal, and the other is it's not a plea agreement and the defendant has a right to appeal.
It's not a plea
It-
agreement,
Right.
so that's correct.
Okay, so what, with everyone's permission, then I'm going to erase the check mark on the defendant has waived the right of appeal because it's not a plea, so he will have some right to appeal.
Yes, Your Honor.
No objection.
Also, on each of the paperworks on the post-conviction waivers that you both signed, I will mark that out as well because that's saying that he's waiving his right to appeal.
Yes, Your Honor.
No
Okay,
objection.
all right, thanks. So,
Your Honor, I would note too, I think I had a few stray, I'm a left-hander. I think there's a few other stray marks on there that
Okay.
I tried to erase and wasn't able to. So
Gotcha.
if you see those, I apologize.
gotcha. We
My hand
we
taps.
understand the left-handed issues up here. Ms. Werner feels your pain on that. Okay, so I want to make sure you understand a couple of things. You have an absolute right to have a jury come in and determine 2 things in these cases. The first would be to determine if you're guilty or not. And then the second would be if they find you guilty, you could leave your punishment up to that jury. If we go forward this way, you're waiving that right and you're leaving your punishment up to me in each of these cases. And is that what you want to do?
Yes, Your Honor.
All right, state tenders number 1 in each case.
No objection, Your Honor.
It's admitted. Also, sir, do you understand if you're not a U.S. citizen that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, Your Honor.
All right. Is there any evidence that Mr. No is not competent?
No, Your Honor.
All right, sir, in each of your cases, I'm going to find that you entered your pleas of guilty freely and voluntarily, find that you're mentally competent and you understand the nature and the consequences of those pleas, find sufficient evidence to find you guilty. However, I'm going to reset your cases for a sentencing hearing so that the probation department can do a pre-sentence report. That'll give me more information about you, your cases, and then we'll come back later for sentencing. Obviously, if there's anything important that you want me to know, get that information to Mr. Franklin. He will present it to me on your behalf when we come back. Do you guys anticipate a little bit of extra time on this one as far as witnesses or argument,
Just brief, not much.
but a little more than normal?
Yes, Your Honor.
Okay, so if I were to set it at 11 on a docket date, we could, maybe an hour would be enough? Or do you
Yes,
think
Your
we
Honor. I
need
think
some?
an hour.
Okay, all right, so we'll reset it for sentencing and we'll just do it at the end of a docket so you don't have to sit and wait unless you have some other cases. You need to stop and talk to probation on your way out of the courtroom and she's sitting at that desk right over there. All right, we'll see y'all back at sentencing. Thank you.
Thank you, Judge.
After an intense session of legal maneuvers and emotional confrontations, all 5 defendants face serious consequences. With probation violations, missed court orders, and shocking confessions, Judge Raquel West made it clear the law is not to be messed with. The final verdict. It's up to the judge, and the consequences are dire. Who do you think is getting off easy in this case? If you found this case as shocking as we did, hit that like button, share your thoughts in the comments. And don't forget to subscribe for more jaw-dropping courtroom breakdowns.